Recording. Awesome. So this platform is World Financial Group. My name is Odetta King. I am a senior marketing director. And one of the things that we do here is we are really, really big on teaching our community everything when it comes to building wealth and preserving wealth. And like everyone, let's see, who was that? Okay, guys, if you can do me a favor and also make sure you are muted so we don't have any interruptions. So tonight we have the pleasure of having one of our estate planning attorney. This is truly a gift, none other than Mr. Phil Borges. He's been working with individuals and business owners for over 25 years, okay? And focusing on creating specific plans for clients' needs when it comes to estate planning, business formation, operations, and exiting strategies. Really great at helping individual with estate planning, which is what the focus is on tonight's webinar. Asset protection, tax planning, succession planning, just bringing peace of mind to clients. And so without further ado, I'm going to turn it over to Attorney Phil Borges. Take it away, Phil.
No, thank you. I'm glad everybody's here today. I really enjoy this platform that World Financial Group has out here because, you know what, we can only make such good decisions when we don't have any information or knowledge. All the topics they teach on are great topics to learn about. I get to be here to talk about the estate planning side of things. But you know what, like I said, you can only make such a good choice if you don't have the education. So we need to go out in the education, and I appreciate they're doing this. They bring me on to do it, and then we go out there because people have a lot of misconceptions about everything. Estate planning is one of them. You know, most people when they're talking about estate planning, the first thing that comes to mind is how do I make everything go as smoothly as possible when you pass away? How do I keep things out of court and have all my wishes carried out? Well, that's important, but estate planning is broader than that. We also have to deal with what happens if we become disabled? Dementia, Alzheimer's, any other things, brain trauma. These things happen. And if you don't have a plan, you're going to end up in guardianship court. Guardianship court is the court where the oversees the determination of whether or not somebody is now incompetent and needs someone else to be their guardian and handle their affairs because they cannot anymore. So this disabled person is then, they're looking to see if this guardian is a suitable person to be the guardian for the disabled person. And then after that, the court stays in their life the entire time this person remains disabled. When it's something like dementia or Alzheimer's, that means until they pass away, because they don't have a solution to get us better from that yet. So it's the rest of their life. The court's in there. You have to pay fees every year, call the bond. You have to file paperwork, which is, you know, how you spent and handled all the assets of the disabled person, information about how you treated the disabled person, all the care that they got, and things that were going on with their health. You have to keep jumping through those hoops. So I hear one of the misconceptions I hear is, I'm married, I don't have to worry about it. My spouse can handle it. Well, your spouse can handle some things. You know, if you have an account together, of course, their name's on it, it's their account too. But I had a couple married for over 50 years. She just called to ask if she paid the premium on the health insurance policy. You know, like a supplement or something like that. And the response, I'm sorry, without his permission, we can't speak to you about his policy. Well, his dementia is so bad, he doesn't use words anymore. He just makes noises and grunts and makes noises. So obviously, he couldn't give permission. So then we had to go through the process. I already tell you, they're going to be in this for the rest of their life, what I just told you before. But in the process is this was so hard on their family. First of all, we had to get paperwork, file paperwork, pay for a bond, pay filing fees, do all that stuff. But then we had to send the sheriff out to serve him because this is an adverse case. They're two opposing parties in some way. Someone's trying to be guardian, someone and declare someone incompetent. So the sheriff had to go out and serve him. Thankfully, he didn't really know what was going on, so it didn't really matter. They had to drag him in court, ask him questions to prove that he's incompetent. Then they had to question her. She was like, "Why is everyone questioning me? I'm just trying to run my family like I have for the last 50 years." Well, the judge didn't really think that she was going to do anything wrong, but she got questioned like, "Hey, I'm making sure that you're not going to steal this money. You're not going to do anything wrong. You're not going to take it for yourself." Because that's what the judge has to ask her. She felt like she was betraying him and their marriage by doing this. But she had no choice. There's nothing else she could do because they didn't learn. They didn't know beforehand. She even said to me something, "Why didn't someone tell me this? We would have done something different." I'm like, people weren't out there educating her. They weren't in their circles doing it. So that's why it's so important to get out there and educate people on everything. Because we could have avoided this. Could have all been avoided if she had some legal authority to act on his behalf. And we do that through a power of attorney. Some of you may have used a power of attorney before. In real estate transactions, we do it, at least around here, we have it all the time. I act as power of attorney for someone so they don't have to go to closing and I can sign off on documents. So we have these things. There's two powers of attorney. One handles your financial decisions. One handles your healthcare decisions. Another document that I consider these three documents, two powers of attorney, is the third one called the healthcare directive, or sometimes referred to as a living will. I consider these essential for every adult that's 18 and over. Everyone, because you never know what's going to happen. I've been going around telling some people, going, "Hey, if you went to call, your kid was in the hospital, who's at college, so they're all 18. I'm sorry, yes, they're here. I can't give you any further information because that's their private health information. I can't talk to you about it without authority." I remember carrying, when I was in college, carrying a lady from one part of campus to another part to have her sent off in an ambulance because she needed to get her stomach pumped. So, I mean, things like this happen. And then one of the people who came to me to get it for their, late teens or early 20s kids to get it done so they could have this authority still, she told me about a story of one of their neighbor's kids. I don't remember what it was. I don't remember if he fell and hit his head, if it was a car accident or whatever. But there was enough brain trauma where he's going to need help for the rest of his life. And now mom has got to report every year and pay a bond every year just to take care of her kid like she wants to, because he's 20 something. Now he needs a guardian because they didn't know any better. And who would have ever thought with a 20-something-year-old that something's going to happen like this? So we need to make these decisions. We need to take these things, put these things in place so that we can not have to deal with going through this court. So like I mentioned, the last document is a healthcare directive. This one says, if I'm suffering from an irreversible, incurable injury, disease, or illness, not to artificially prolong my life. So this is an end of life decision and your feelings about life support. If you are not going to live without life support, do you want to stay in that situation or not? A lot of people don't. Some people would like it to be longer and put terms on it. Whatever is right for you, because these are your plans, your wishes. We just need to let other people know. Because if you don't let other people know, we could have a situation like Terry Schiavo in Florida. It's been, probably 15, 20 years now. This happened. She was in a coma. She'd been there a while. Doctors kept saying, yeah, she has no brain activity. They're keeping her alive on machines. Husband decides, okay, I guess it's time. Parents said, not so fast. They sued him. And then they're fighting in court, trying to decide who gets the right to make a decision, whether it was the husband or the parents, and what that decision should be. She died in the process, but that's not what we want happening in our families if we were in that situation like that. So we need to let them know. Let them know what our feelings are, our decisions are in that situation. And another reason we need to let them know is because that agent under the power of attorney for healthcare, they need to know that they're not making the decision in some ways. Yes, they're expressing it, but what they're expressing is your decision of what you want in that situation, but unfortunately are unable to make it because you're in a coma or whatever situation you're in at that point in time. Because no one needs to feel guilty about expressing what you decided. They're just expressing what you decided. So we don't need guilt there. We're going to have sorrow, we're going to have loss. But guilt does not need to be one of those feelings, because if they know what you wanted, then they can feel comfort in doing, just saying, hey, I did what mom, dad, brother, whatever, whoever this is for, is making the decision. I'm doing what they asked me to do. It's like my final thing that I did for them. So those 3 documents I consider essential for every adult in the United States, because you never know what happened. Financial power of attorney, healthcare power of attorney, healthcare directive. The next thing that we have to deal with is death. So death, the court's called probate. Probate oversees the transfer of assets from a decedent to the new rightful owners. If we fail to act, it's called intestacy. The state has put together what's going to happen to your assets. It might be what you want, it might not be what you want. Every state's a little different, based on, if you're married, if you have kids, if those kids are of your spouse. I mean, there's all sorts of different provisions that go in there. And like I said, many states have different ones. There was one couple that I know, well, I guess it wasn't a couple, I never met her because she had passed away. She was the owner of their business, it was a small business. And that state's provisions were half goes to surviving spouse and half goes to the children. Their children happened to be in grade school. So every time he was trying to pull money out of the accounts for the business to pay for things to raise his kids, he was supposed to be paying them the same amount. So certainly wasn't what they want. So how do we let it know what we want with everything? It's a last will and testament. The last will and testament tells that probate court who you want to handle your affairs, called your executor. Who you want to handle, receive your assets and inherit them, called your legatees. And if you have minor children or are a guardian for an adult disabled child, or even adult person, if you're just guardian for someone, who you'd like to be the guardian for those people at that time. But again, this is court. Court is hoops, court is fees, court is time, court is public record. So the way the probate court works is you have to file your documents. And from the time the decedent died until the time an executor or administrator is appointed, no one has legal authority to do anything with those assets. So if you needed to get to that account to pay bills, not allowed. If it was some sort of investments and a meltdown was happening, can't change it. You're stuck until it happens. So you can get in there. And my guess is, it's going to take a little bit of time between the person dies till you get in and file your paperwork. And then when you get to file your paperwork, it's probably at least 4, if not up to 8 weeks before you actually get in front of a judge. Then a judge appoints an executor. Maybe you had to pay a bond, maybe you didn't. But then the whole process goes. You file in the newspaper to let creditors come out, you deal with the creditors. You may file an inventory. This is a list of all the assets that the decedent had, public record. And then before you end, you file an accounting. This is where everything goes, whether it was paying anybody, paying any creditors, or the amount of people, who inherited and how much. So if you went in there and saw that someone could go in there and see that somebody inherited a lot of money, bad guys might get some ideas with that. But it's all public record. You can literally walk into the courthouse, and these days it's just jump on their computer that they have in there, and you just look it all up. Just right there, hit print. Copies at the courthouse are usually expensive, but if you wanted to look some up and print it, you can do it. So how do we avoid all this? There's a few ways that could happen. One is that there's forms of law that have property pass automatically. The first one is a joint tenants with the right of survivorship. So when one person dies, the other joint tenant is just the owner of it. Many couples have, joint bank accounts. They own real estate jointly, which there's another one called tenancy by the entirety, which is a special one for real estate for married people on their homestead. So they have these different ways where it is passed on to them. So these properties. Well, that's great for when the first one dies, but what happens when the second one dies? Or if it was something where they were really close together, like a car accident or whatever, it takes them both out. Now we have probate. Some people will say, okay, I'm gonna put my kids on it. Well, you can't if your kids are young. They can't own things until they're an adult. But if you do put them on, it's their asset. So if I put my kids on my bank account, they could spend the money if they want because I gave it to them. It's theirs now. It's still mine too, but it's also theirs. So they could do whatever they want. If they had a creditor for some reason, the creditor could come after it. Say they, were driving and conditions were bad. They slid and a big accident happened. Or maybe later in life, they have a dog and the dog mauls somebody, just flips and mauls somebody. Those can be big judgments against somebody. Big judgments go above insurance premium or insurance proceeds that the payout, the insurance, the amount you're insured to, and then they go after personal assets. When they see those assets, no, they aren't moms and dads. They are those kids, and they're going to get them. They on their house, they're going after the house, put a lien on the house. So that's a problem. That could be a problem. Or you could be like, hey, I put all of my kids, how many ever there are. So if you say someone had 4 kids, so the parents with the 4 kids on there, now they want to downsize. Sure, the kids are all on board for it, but now all the kids have to sign off on that deed and all those documents to do it. It's kind of a headache. And lastly, you could have somebody like this one guy. Oh my gosh. So his parents wanted to get a reverse mortgage, do some financial planning and free up cash flow or whatever they're doing exactly. They kept telling me, look, we've got a problem. We can't get this. I'm like, why not? He won't sign off. Yep. Their son said, no, I won't sign off because that's my inheritance and I'm not letting you spend it. I don't know how someone knows that to a parent, but apparently that guy does. And the last reason why we don't want the joint tenants is not with a right of survivorship is not as efficient as some of the other ones. It's a tax reasons. So if we buy something at a price and it appreciates over time and we sell it, that's a capital gain. We pay taxes on our capital gains. If we give it to somebody, which putting someone on as joint owners with you, that's giving it to them. Well, they would have retain the same basis, and so they would pay the same capital gain. However, if it was something they turned around and sold after you died and they inherited it, under current law, you get a step up in base at time of death. So if the price is here, it steps up to it. There's no difference in your basis and your price. There's no gain, no tax. So it's less efficient for those types of taxes. So those are the pros and cons with joint tenancy with the right of survivorship. The next form of law that we can look into is beneficiaries. Beneficiaries are great, and you should put them on every single account that you can. Life insurance, annuities, retirement plans, brokerage accounts, bank accounts, all of them can have beneficiaries on it. They might call them something different, like especially the bank accounts, but it's essentially a beneficiary. But there are drawbacks. One, what happens if you wanted to say to my spouse and to my kids, like maybe like that couple that I said their kids were still in grade school. Now these assets, if something happens to your spouse also, now these assets are held in a custodial account until they're 18 and then given to them. If it was $1 million life insurance policy, maybe it's okay. Maybe you're afraid that the kids might be a little not savvy enough to handle assets of that value. I don't know. So it's your personal decision of whether or not you think you should leave those types of assets to your kids. And a lot's going to have to do with your kids and how savvy they are, how good they are with money at that point in time. Another thing is what happens if maybe everything was good at the time, but something happened. Maybe we were leaving it to that boy that I told you about who had the brain trauma. So he gets Social Security supplemental income or SSI, SSDI. He's on Medicaid. Mom and dad are still supporting him, so I'm sure they haven't applied for food stamps. But if he was a little better off where he could live on his own, but just couldn't really hold down jobs, he could get food stamps, rent subsidies. If that money hits his bank account, loses all his government benefits. So what if something happens like that? What if someone's in a situation where we have creditors? One client of mine, she was going through a bankruptcy. If that got to her bank accounts, all those medical debts, they would have started claiming some of that money, or at least trying to, or the bankruptcy trustee may have been trying to get it, claim that money to pay off the doctors and hospitals bills that she had racked up. But we were able to hold it back because we had ways to hold that back at the time. So we were able to save that money for her and let her get restarted after getting through all of her medical things. There are many other reasons why. Maybe we don't want drugs, alcohol, gambling addictions. There are many reasons why. Maybe if I had no choice but to give it to him directly, there'd be an issue and we'd have a problem. Maybe we don't want to necessarily say, boom, automatically yours at the time of death, because we don't know the situation somebody's going to be in at that time. And maybe they're going to be in a situation where we don't want them to have it. Maybe we can use it for them, save it for them, hold it for them, but not just have to be required to turn it over to them. So that leads us to the last way we can avoid probate. And that's you don't own anything. If you don't own any assets, there's no assets to go through probate. Now, I'm not trying to say you have a crystal ball and spend your last dollar as you take your last breath. What we do is we control assets. We use assets. We just don't own them. Rockefellers were famous for saying things like this. And the way we do this is through a trust. The typical trust for a probate avoidance is a revocable living trust. It's revocable means we can change and amend it, revoke it at any time we want, as long as we still have mental capacity to do so. Living means we did it while we were alive rather than testamentary, and when it was done after we died through our last will and testament. There are three main parties to a trust: a grantor, the person who creates it; a trustee, the one who controls the assets; and the beneficiary, that's who we're using them all for. These probate avoidance trusts, you're all three parties. You create it, your trustee and control it, your beneficiary use it. So all my assets are in this trust. I control it however I want. I use it however I want. I just don't own it anymore. My trust owns it. So now I can avoid probate because I don't own the assets anymore. The last thing is, it's a little low, but getting these documents, signing on the documents, getting them all executed so they're in place is not the last step. The last step is we have to fund the trust, put things into the trust, change beneficiaries, move real estate into the trust, whatever other thing, move other assets in the trust, because if we keep them in our name and don't move them, we just went through a process that didn't do anything. So those are the basics of estate planning, just the basics. There's more, which I'll go into in a second. But those are the things that go ahead and make sure that we can avoid probate and we can get our wishes carried out. These wishes in this trust. I don't want kids to get it until they're 35, 45, 50, whatever the case may be. I have a client who literally said 50 and his clients are still in their 30s because they didn't want one of his boys to get frustrated at work and say, I quit, I'm done. And have a little extra courage to do that. I don't think they would have. I met them both. I don't think they would have. But hey, that's what his wishes were. That's why we create them specific for everybody, everyone's situation. So we can put that on there. We can put on other claims like, hey, I don't want to give it. I was talking today. We're putting on things where this one of the ladies, I've had a few of these, someone isn't very good with money, and we don't think they're going to be. So we're never going to give it to them in a lump sum. Someone else is going to control it for them and divvy it out. Or if special needs people, where we have to hold it back to make sure that they don't get it, because those governmental benefits will get lost. You know, if someone's dealing with creditors, we can say you hold it back. That's how we held it back for this other lady. So it was in the trust. We said we didn't have to distribute it because of spendthrift reasons. So we could hold it back until she was free of all those debts. So what we need to do is we need to express our wishes and then get it all created, especially for you. Sometimes, you know, very basic, straightforward things are good. Other times we need to address different issues and different things that are going on in someone's life to make sure that we handle things. The basic trust does not do any asset protection. So if you get sued, those assets are still exposed. It does not do anything for Medicaid spend down. So if you end up going to a nursing home, you have to spend all your assets down to $2,000 approximately before Medicaid, which you paid for your whole life, by the way, in your taxes, they won't pay for anything until you basically have nothing left, which is unfortunate. But it's even more unfortunate and tragic is some states require a stay-at-home spouse to only have $50,000, $110,000. Some would make them have just a little bit of assets, and then the house, the car, and things like that, and only a limited amount of money they can keep. You don't want to leave them home broke. So we've got to deal with that and look to make sure that, you know, for some elderly people, you have to look forward to that, whether it's through the long-term care insurance or we have to do Medicaid planning because they just don't have enough money or aren't healthy enough for it. So those other things are not in this basic trust. Tax planning isn't usually in the basic, or it's just minimally in there, if anything at all. Those require other things, which is also one of the big differences between different trusts. I said the first one was a revocable. It means we can change it. But there are irrevocables. And the reason why we have those is because now as grantor, we're not retaining the right to amend it. And we can go and do things and have things like special needs trusts. We can have things like some domestic asset protection trusts and other different trusts out there that do other means. So irrevocable life insurance trust. So I can get that death benefit out of my estate, because if I have an incident of ownership, the entire death benefits in my estate for estate tax purposes. So I did see there was a question. If anyone else has any other questions, you can go ahead and unmute yourself and go ahead and ask. Reverse mortgage. Oh, the reverse mortgage was only an example. Didn't have anything to do with the reverse mortgage other than the fact that the son was part owner of the house. So whenever you're doing something, a mortgage, reverse mortgage, a lien or something on the house, everyone as owner have to sign against it and agree to it. He didn't agree because he didn't want his parents to use up any of the extra equity they had in the house that he was counting on as his inheritance. That's what the reverse mortgage was about. But is there any other question that anyone has right now? Wow, I must be doing a good job. Everyone's staying silent.
Okay, Phil, I have a couple of questions that came in. So you mentioned that there's 3 documents that everybody needs to have. Can you repeat those 3 documents?
So, okay, so these 3 documents are all about disability and end of life. Because even if you have no assets, I think you need these so we don't end up in that guardianship court again. It's the 2 powers of attorney: a financial power of attorney, healthcare power of attorney. And the last was the expression of your feeling of end of life and life support type issues. And that's your healthcare directive, also sometimes referred to as a living will.
Okay, someone posted a question, how can we fund our trust with LLC and corporation?
So an LLC, the owner of an LLC is a member. So what we do is we make the member of the LLC the trust. We make it manager managed, not member managed. So then the manager, you appoint yourself as manager. So now I'm manager of my trust. I have the legal authority under manager. My name does go on the state records in most states as the manager, so everyone knows who they can deal with. But I'm the manager, the member is my trust. So now it's in the trust and it doesn't go through probate. Corporation is about the same thing. I go on as a director or an officer or something like that, and I elect myself that. But my shareholder, the owner of the corporation, is the trust. So they own the shares of stock. So those shares of stock, depending on their value, wouldn't have to go through probate.
Okay, good. I love it. Looks like the questions are coming in. So who needs a will? Who needs a trust? And how long does a trust last?
Who needs a will? Anybody, if you have a child, you need a will because you need to say who you want to be guardian of that child. If you have assets that you care where they go, you need a will at the very least, because the will tells everybody who you want to receive those assets. I mean, I suppose if the intestacy laws does exactly what you want, maybe you don't have to, but you do. Anyone who wants to avoid probate who has assets needs a trust, because we need to get those trusts out of those assets out of our name and into that trust. Unless everything has a beneficiary on it. If you want to put strings on how things get to people, you need a trust, because you can't put strings on a beneficiary. You can't have the control from the grave saying, okay, you get this only in these circumstances or times or whatever else you might put on it. Then, I mean, there's other times and places that need trust, and it's just as the more complicated it gets, your situation gets, the more likely you're going to need some sort of trust and planning device to make sure that your wishes are carried out. Now, I've had people tell me, I don't care if my family goes through probate. I'm not here. I don't have to deal with it. So they didn't get a trust. But you know, they're sending their plan is to send their family through court.
There goes for the people who like to say, well, I don't care what happens after I die. Let them figure it out. Okay, well,
Exactly.
that shows how much they love their family.
Now,
Okay.
I mean, most people want to make things as smooth and painless as possible. There's already, as I said, grief and everything, a loss going on. So why are we going to add, all right, here's a headache on top of it for you? I did have one guy tell me one time that I was in a workshop and he tells me in front of the whole room, and it's like, oh, perfect. I love when I get these stories from people. He says, you know, I felt so honored they named me executor under their will. And then he went through it. He went through the probate process. He's like, I never want to do it again, and I never want to send anyone through that process. Every little hoop that he had to jump through, it just got to be kind of consuming and everything with it. So it's just kind of a pain to go through and make sure that you get all the documents right, have all the court dates that you have to have, and have everything over. And if there's arguing, oh my gosh, that can take forever. I had this couple, these two girls or daughters that, shouldn't call them girls since I think they're as old as I am. They argue. The one was trying to pull some of the assets out and keep them and keep from her sister, and the other one wasn't having anything. We were in court every 3 weeks, 3 to 4 weeks. Their house, I mean, there was a lot of stuff. I won't call it junk because some of it had lots of value, but they were collectors. So they were going to collect it and sell it, but they never got around to selling it. Mom and dad were. So they had a house full of stuff, and the house was probably worth a few $100,000. The one girl wouldn't let us sell it for under 600, and I'm like, no one's going to buy it for that price. We're going to be here forever. So we ended up racking up bills. I think that out of an estate that had like $350,000, I think we had $110,000 of lawyer bills, just because of how much the fighting went on. You know, when you're going to court every 3 or 4 weeks for a couple of 2, 3 years, bills add up, and none of us, I can tell you, none of us lawyers even wanted to be there. We're like, this is just ridiculous. But we all had our clients, we had to represent our clients, and that's just the way it is.
How long does the trust last? So let's say once the person dies, is there like a deadline or a time frame when it no longer is, or can someone set up a trust, they're long gone, dead, very rotten, and the trust still lives on for like 100 years or 60 years?
So there's states all have different ones. Alaska is 100 years after the last person named and it dies. The common one is 21 years after the last person in the document who's listed. That's the shortest one for any of these, unless you put in the trust and only, I suppose you could terminate it after a certain period if you wanted to. I don't see any reason why you would, but you could make it in the terms. But I mean, they go from every life and being in the list of the trust plus 21 years, and that would, after the last one dies, is like the shortest one, and everything else goes from there. And there are some states that have dynasty trusts that can last forever.
Wow. Okay, so let's look at the chat. We have someone that said, did you say do not do a joint tenancy?
So joint tenancy has its pros and cons. The pro is it'll pass to the next one, but if the two people die at the same time, like car accidents on it, we're in probate. So if you wanted to avoid probate, you just didn't. There's also tax implications, like the capital gains tax. If I joint tenants, they get it as a gift, not as an inheritance. And so there's a different, if there's been appreciation over the years, they don't get that benefit of that stepped up basis. And they also own it, so they can expose it to creditors too of theirs, not just yours. So there's some reasons why you might not want to do it. However, it is easy. It is easy to do. I know a lot of people say, all right, I'm putting somebody on the account, on the bank accounts to pay my bills when they get old. My mom just put me on, like, not mine, but someone says my mom's just put me on the bank account so I could pay her bills for her. Okay, it's fine. I mean, I don't, like the one I'm thinking of, I'm not worried about him having creditors or doing anything wrong, and it's not a big bank account either. So stepped up basis, and it's cash, it's a bank account. So it's not like there's appreciation in it. But if he got sued, could come after mom's bank account. Tenants in common, I see that one. Tenants in common are two people owning equal shares. Tenants in common does not pass to the survivor. That's like if two people have it, it would be described as an undivided 1/2 interest. So if I have tenants in common with you, if something happened to me, my share would go through probate or go to whoever I want it to go to. Your share, if you want to give it to someone else, you could give it to someone else too. It doesn't go to the survivor.
Okay, irrevocable trust or revocable trust. What is your best recommendation to protect assets within the trust with flexible management? So first of all, I guess maybe you could say what's revocable and what's irrevocable, and then just say, what do you think is the best recommendation to protect assets within the trust with flexible management?
So the flexible management, if you're talking about just managing the assets, so like I control how it's invested, but I have no control over how it's dispersed, then I can get you asset protection through an irrevocable trust. If you want to have control over how it's dispersed, how you manage it, and so I can pay it out to myself at any time I want, you're not going to get any asset protection. It's just not there. So whether it's revocable or irrevocable, it's not going to matter. It all has to come with the separation between that trustee and the beneficiary, and whether or not they're required to pay it out or if it's discretionary or not. So if I said to my kids, but I pay out 25% at 25, half of it at 30, all of it at 35, when that 25 hits, that 25% is creditors can come after it. even though, they may not have control of the assets, that one, there is no discretion anymore on that part. The other rest of it, there's still discretion on whether or not to give it to them, so the trustee wouldn't have to pay it out. But you need the separation of a trustee and a beneficiary to have any asset protection whatsoever. So it's kind of a hard question. I mean, whether you do irrevocable, revocable, asset protection, tax planning stuff, it's all going to depend on every situation. Just have to make the plan that's going to work for you and your situation, your family.
Okay, I think we have 4 more questions and then we're going to wrap it up. Does life insurance need to be in a separate trust that includes only life insurance, or can other assets be added?
So there is the one irrevocable life insurance trust, which is for tax planning. So there are possibly 2 different, they call them death taxes. There's an estate tax and there's an inheritance tax. Inheritance tax bases on who receives your assets. Most states don't. Very few states have an inheritance tax. Well, very few states have an estate tax too, because there are 38 states that have neither one of them. The estate tax looks at the whole totality of everything you own, or they say incidence of ownership with at the time of your death. And then they assess a tax if you're above a certain threshold. Some states have a lower threshold, like I think it's Connecticut and Washington, and are about $2 million. Maryland's like at 5, Illinois is at 4. So they're all different ones, all different levels. If you go above that, you pay a tax on it. Taxes are different tax rates. They run up at different paces. So the irrevocable life insurance gets that out of my estate. And that's the purpose of that one. Your other life insurance, if you're not going up near or over those numbers, it doesn't really matter. And I actually usually have the life insurance pay into this revocable trust, so it all can be managed together. The other little caveat about estate taxes, the federal government has one. It's up there. It's $12.92 million a person this year. Will get cut in half at the end of 2025, so it's still going to be $6.5–7 million then. And that's per person, so each of the couple gets to use that thing. So we still have a lot of leeway in there.
Okay. Could you please explain the difference between healthcare directive and healthcare power of attorney?
The directive is an expression of our wishes of what we want to have happen. That if I'm suffering from an irreversible, incurable injury, disease, or illness not to artificially prolong our lives, the healthcare power of attorney gives someone legal authority to act on your behalf, to make those decisions. The directive doesn't give anyone any legal authority. It's just an expression of our wishes.
Okay. If I'm a single parent, what do I need so that I can pick who I want to have guardianship of my child?
That goes in your will, your last will and testament, where you name who you want to be guardian of the child. Now, a single parent, the one little thing about that is, unless parental rights has been terminated with the other parent, or the other parent, something happens to the other parent before you, it'll almost always go to the other parents if they still have parental rights and joint custody or anything along those lines.
So where does legal guardianship fit in with this when it comes to underage kids?
Well, if you're underage kid, someone needs to, if something happened to you and you can no longer be there, you're no longer able to care for them. So in some ways you're like their guardian. As a parent, someone needs to be able to do things for them, make decisions for them, because they have being underage, they have no authority to even, own assets, to enter contracts. They can't do any of that stuff. So someone has to be their guardian to handle things on their behalf until they become an adult. So in the probate court, after you die, that's one of the things that you can't get around probate for, is they would have to go through and say, name a person to be guardian for any minor children. Or end of life guardian for a disabled person too, like, an Alzheimer's dementia type thing too.
So what I'm hearing is in addition to the will, we still need to have a legal guardianship if there's minors. We need to have.
No, the will says who you want to be your guardian. Then the court issues a document, an order naming someone guardian. So the actual documents for the court that name and appoint someone guardian come from the courts. We just say who we want to be through our last will and testament. And it'll get followed unless there's some real strong reason why it's not in the best interest of the child. Other than the other parent thing, the single thing that your other parent's still alive, that too.
I'm going to do 2 more questions and then we're going to wrap it up. Massachusetts common law trust versus regular trusts, which would be better, pros and cons?
So they're very similar in what they do and everything. I mean, the trust started out of common law, and then they became developed into some, they codified in some laws in the states. I don't know that there's a whole lot of difference. I mean, Massachusetts also has a business trust, which is another form of business ownership. There's like 3 or 4 states that follow that and allow that to be in there. I don't know that there's any real pro and con other than that when you're in Massachusetts, you might use just the common law trust instead. You're not getting any asset protection. You're not getting any extra benefits out of it. It pretty much does a very similar thing.
So I see a question about cost of trust and who can we contact. Every one of you were invited by someone, so definitely get in touch with the person who invited you, where we will set up an appointment with one of our esteemed attorneys. Every trust plan, depending on how complex or simple, will be obviously at a different price, depending on how much work needs to be done for the trust to set up. So definitely, we're going to conclude this webinar, but we will have another one in a couple of weeks. All of you that register, you will get a copy of the recording so you can listen to it again. But most importantly, once we hang up, please get in touch with the person who invited you. If you saw it on Facebook, if someone sent you a text, if someone called you, get in touch with the person who invited you, and we will point you in the right direction as far as setting up a one-on-one appointment, free consultation with an attorney like Phil Bourges, and who will, speak with you regarding your specific situation based on what you need, because just like taxes, everybody's situation is going to be different. So we don't want to tell you it's going to be 5,000, 1,000, 400. We don't know what your situation is going to be like. So speak with the attorney, get a thorough, free financial consultation for your specific needs. Some people may have a lot of things. Some people may not have a lot of things. So the pricing is going to be different. So with that being said, we're going to conclude. There's only one question.
The one thing I can add to that is we do bill for almost everything in flat fees. So you'll know what your fee is going to be before you tell us to go ahead and start going through everything. And you'll know the process, how we go through everything. All that's laid out in our consultation.
All right, guys, it is right up the hour. I know you guys want more. That's why you're going to get in touch with the person who invited you, and we'll get you in touch with a one-on-one free consultation. Thank you guys so much, and we'll see you. Actually, we have another webinar tomorrow. Actually, let me drop the link. Usha, can you drop the link in the Zoom chat? We do several different webinars on different topics, all personal finance, from life insurance, investment, savings, debt management, and building wealth, all different topics. So if Usha, let's see, Usha, can you drop the link for tomorrow? We have another financial webinar at 8 p.m. tomorrow. We have another one on Monday, which is going to be on wills, medical proxy, power of attorney, final expense. So definitely get in touch with a person who invited you so you could be in the mix. And like I said, all of you that register, you will get an email with the recording, and also my contact info. I'm going to drop it right here right now. So for some of you who want to register for the next webinar, you can go ahead and register. Well.com. And if you want to set up a one-on-one consultation, you could also click on the link that I'm putting in the chat. Okay, so if you want to register for any of the next upcoming webinar, go to odetaking.com/health and wealth. If you want to set up a free consultation one-on-one, just click odetaking.com/stack your coins. If someone specifically invited you, circle back with that person so they can schedule a one-on-one and get you with one of our estate planning attorney to go over your specific situation. Thank you guys for joining, and we'll see you tomorrow, 8 p.m. on the next webinar.
Thank you, everyone. Have a great evening.
In the Black community, financial literacy is very important. See, there's so many people just like myself who were never exposed to the information so that they too can make sound financial decisions.
Without financial literacy, our next generation will be left behind.
We've not been able to keep our dollars in our communities. We've not known where to put our money to gain growth, protection, or to create wealth.
There was nothing that my parents were going to be able to leave us. It's important to me and to my community because in the Black community, no one is receiving inheritance from their parents. And we have to change that.
Financial literacy is the gateway to freedom. It is the gateway to helping to leave a legacy for my family.
And it does not depend on who I am as far as a race, being a woman, or anything of that matter. All it takes is someone who has a willing mindset. So I'm just so grateful to have a platform in my life that gives me not only a system to follow, but also a lifestyle that I can live, that I can enjoy, and I can pass down to the next generation.
What I want to do through WSB and through the financial literacy platform is take that out into our communities to help our Black families understand and know that they too have hope to build a solid, firm financial foundation.
Even though I made good money, nobody educated